and he would be brought to trial and he would be convicted. So we're not really that interested in the armed robbery charges per se. This is really the meat of this appeal, but the part we're interested in is the BB gun issue. So let's scroll down until we get to that. So BB gun is a deadly weapon. Serna Lopez, the defendant convicted, now the appellant, asserts that there was insufficient evidence for a reasonable jury to conclude that a BB gun is a deadly weapon. He was convicted of an aggravated form of robbery, so armed robbery with a gun. The gun adds a lot of prison time as a sentencing enhancement. But it needed to be either an actual gun or reasonably perceived as a deadly weapon. Now, the BB gun. So the question becomes, can a BB gun be a deadly weapon? The Court of Appeals addresses this claim and rejects this argument by Serna Lopez. Standard of review, the court's looking at this question. The appellate court is looking at this question de novo. De novo means as if it had not been analyzed before at the trial level. They're applying, the Court of Appeals is applying their own judgment here. A lot of times the Court of Appeals is not applying their own judgment. They defer to the discretion of the trial judge on things like whether or not a piece of evidence should have been admitted or excluded, for example. They will not overturn those kinds of evidentiary decisions by a trial judge absent an abuse of discretion. So in that case, they're saying, listen, we might have come to a different decision than the trial judge, but we don't want to do the trial judge job. We're appellate court justices. So we're not going to reverse what the trial judge decided on evidentiary matters unless it was an abuse of discretion, which is a very high threshold. Here, they're saying we're going to look at this de novo, as if the trial judge had never considered this question. Analysis. Serna Lopez contends that the BB gun found at his feet during the traffic stop was not proved to be a deadly weapon as defined under the relevant Colorado statute, which defines a deadly weapon as a firearm, whether loaded or unloaded, or a knife, bludgeon, or another weapon, device, instrument, material, or substance, whether animate or inanimate, which means it could be a dog, right? Animate. That in the manner it is used or intended to be used is capable of producing death or serious bodily injury. Our Supreme Court has consistently held, this would be the Colorado Supreme Court, that whether an object is a deadly weapon depends on the manner in which the object is used. Absolutely true, folks. So we have a definition of deadly weapon that would apply for weapons law. Whether or not you can legally have it on your person in public, or whether you need a permit to carry that item on you in public, for example, whether it has to be concealed or open carry. There's lots of gun law, weapons law issues here around what's a deadly weapon. And if you're going to be found guilty of a gun crime, a weapons crime, there needs obviously to be some statutory definition of what's the prohibited item. But for use of force law purposes, anything can be a deadly weapon, really, right? Depending on the manner of its use. So obviously something intended to inflict death or serious bodily injury, like a gun or a knife, if used in that manner, would be a deadly weapon. But what about a plastic shopping bag? Deadly weapon? Probably not for weapons law purposes. You don't need a permit to have a plastic shopping bag. But if you duct tape it over someone's head so they can't breathe, is the manner of its use one likely to inflict death or serious bodily injury? Is it being used as a deadly weapon? Sure, of course. A shoelace on your shoe is not a deadly weapon. You don't need a permit for it. There's no prohibition on having shoelaces on your shoe. But if you're wrapping around someone's neck, is the manner of use now making it a deadly weapon? Of course. A fluffy pillow with a kitty embroidered on it, a deadly weapon? Well, if you're using it to smother somebody, it's being used as a deadly weapon. So the manner of use really controls. The Colorado Supreme Court has also continually held that deadly weapons are objects specifically directed toward another in an assaultive way. So you're using it. Assault means literally putting someone in fear of harm. So you're using the item to put another person in fear of harm, which of course is what Serna Lopez did here with his BB gun by pointing it at the male cousin to prevent the male cousin from intervening in the robbery. Continuing with the decision, Serna Lopez's assertion that the BB gun was not a deadly weapon is predicated upon two arguments. One, The BB gun could not be a deadly weapon because he did not use it during the robbery. That's not very compelling. What matters is the state of mind you create in the victim you're threatening. And two, in other words, did they believe it was a deadly weapon? What was their reasonable perception? And two, the prosecution failed to present evidence that the BB gun could cause serious bodily injury because no witnesses testified regarding the type of BB gun that was found, the type and amount of pellets it could use, or the injuries this particular BB gun could cause. Now, when we get to Steve's book, the chapter in his book on BB guns as deadly weapons, he will strongly advocate that if the state does not do this, that the defense should attack the state's failure to get with specificity to the deadly nature of the BB gun, that the defense should hold the state's feet to the fire to compel the state to prove not just generally whether or not BB guns could be dangerous in a deadly force way, but whether this particular BB gun, in the manner it was being used, could fairly, reasonably be seen as a deadly weapon. We'll get to that in just a moment. But these are the arguments on appeal by Serna Lopez. Now, during the robbery, the Court of Appeals continues, during the robbery, Montoya, the male cousin, was unable to help Salazar, the victim of the robbery, for fear that the gun Serna Lopez wielded would cause serious injury. He testified that when he saw the gun, he was scared and said, "Don't shoot me." Montoya also noted that Serna Lopez cycled it back, indicating that Serna Lopez's conduct with the BB gun mimicked loading a bullet into the chamber of a firearm. Thus, while the BB gun was not fired during the robbery, it was specifically used in a manner to keep Montoya in fear and to prevent him from assisting Salazar. Quote, "The defendant need not intend to cause serious bodily injury. He must merely use as a weapon an object or instrument that is capable of causing such injury." That's for the crime of armed robbery. Moreover, contrary to Serna Lopez's argument, expert testimony was not needed. Expert testimony was not needed to establish that the BB gun was capable of producing death or serious bodily injury. That's what deadly force means in the use of force law context, folks, right? It's not only force that can cause death. It's also force that can cause serious bodily injury. Serna Lopez accurately notes that in another case, a deputy sheriff had provided testimony that if a person was hit with a BB in a vulnerable area of the body, such as the eyes, it could cause serious bodily injury. Serna Lopez also correctly notes that no similar testimony was provided here. But we reject the notion that such testimony was a necessary prerequisite to a reasonable juror concluding that the BB gun used in the manner Serna Lopez did could cause serious bodily injury. And here we have a funny reference. Of course, the little image I used for the thumbnail of today's show, this image, is from what? A Christmas Story, I think, right? Where the line is, "Careful, kid, you'll put your eye out." Well, the Court of Appeals actually references this here. Indeed, many a child has grown up with an admonition similar to the testimony given by the officer in JR, and such lessons have made their way into our national lexicon. See A Christmas Story, Metro Goldwyn Mayer, 1983, Ralphie's mother, his teacher, and Santa replied to his request for a BB gun, "You'll shoot your eye out, kid." For these reasons, we conclude that the people, meaning the prosecution, the state of Colorado, presented sufficient evidence to permit, but not require, a reasonable juror to conclude beyond a reasonable doubt that the BB gun was capable of causing serious bodily injury and therefore met the definition of a deadly weapon. Even in the absence of expert testimony on this question. So what the Court of Appeals is saying here is, you really only need expert witness testimony on matters that would be outside the common knowledge of a jury, like, fire is hot, ice is cold, knives are sharp, guns are dangerous. The Court of Appeals is saying here, and if it is outside the common knowledge, if it's something technical like terminal ballistics of a particular caliber of bullet, that the general public would not be expected to know, so a jury would not be expected to know, that you bring an expert witness in to inform the jury. But here the Court of Appeals is saying, hey, everybody knows that BB guns can take your eye out. That's serious bodily injury. Therefore, you don't need expert witness testimony on that question in order for a jury to reasonably conclude that a BB gun can cause serious bodily injury. And serious bodily injury is in the category of deadly force, as we just talked